Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Going to talk about a topic we haven't really talked about before, which is the ban on you possessing firearms at post offices. Now, many believe that this is a product of state law, that states have created these gun-free zones in post offices. Wrong. No, actually, this is all done through federal law, and to be specific, 18 United States Code, Section 930, subsection A. But this law, like many of our long-standing federal gun legislations, are beginning to go through this post-Bruin enlightenment, this post-Bruin awakening, if you would, where we're going back and we're taking a look at some of these laws going, hey, were these even constitutional to begin with in the first place? And that is exactly what happened with this law recently, where a federal judge struck it down because it has no historical analogs. Well, the United States is appealing that now, and so this is getting serious, and I think we probably all ought to start geeking out on it for ourselves. So today, let's spend a few minutes and let's talk about the fight to keep you disarmed at the post office. Okay, so the case we're talking about today, America, is United States versus Ayala. It is a case that originally was filed in the United States District Court for the Middle District of Florida in the Tampa Division. It is a challenge, a now successful challenge to 18 United States Code, Section 930, subsection A. And I gotta tell you, the facts of this case are a little disturbing because Mr. Ayala, who by all accounts was a lawful, responsible citizen, had been employed with the United States Postal System for quite some time, was lawfully allowed to possess firearms by the state of Florida, was in good standing, everything there, occasionally carried a firearm in his fanny pack. Now, one can imagine as a postal carrier going around with all the people you'd be contacting with, yeah, the need to protect yourself might be there. Now, was he accidentally discovered? We don't know, but what we do know is postal inspectors showed up at work one day and took him into custody for that reason. That's right, he got arrested at his own job because he was exercising his own inalienable right. You can't make this stuff up. Now, he was indicted under one count of 18 USC Section 930, subsection A. He then challenged the constitutionality of it. He said, hey, wait a second. This law has no historical analog to support it whatsoever. It's unconstitutional. I'm being prosecuted under an unconstitutional law. The trial court ruled as follows. The United States indicted Emmanuel Ayala, a postal worker, for possessing a firearm in a federal facility in violation of 18 U.S.C. Section 930, subsection A. Ayala argues that the statute is unconstitutional as applied to him because the historical record does not support a law banning firearms in post offices. Relying on dicta from earlier cases, the United States responds that the Second Amendment allows it to punish the bearing of arms inside any government building. But the Supreme Court has been clear. The government must point to a historical principle that would permit it to prohibit firearms possession in post offices. The United States fails to meet that burden. Thus, the court dismisses the Section 930A charge because it violates Ayala's Second Amendment right to bear arms. Now, kudos to the trial court here, who basically stuck with a really simple Bruin analysis like it's supposed to be done, which is we're going to presume that the conduct is covered by the text of the Second Amendment, which it is. And from there, it becomes the government's burden to show through historical analogs that we as a society have accepted these types of restrictions in the past. Now, does the government need to come up and say, aha, going all the way back to 1750, here's a restriction on firearms in post offices? No, they don't. But they need to come up with something somewhat similar to that as to the how or the why. The problem here for the government, as expected, is they couldn't even come anywhere close to doing that. The trial court found the United States concedes that there is no evidence of firearms being prohibited at post offices specifically, or of postal workers being prohibited from carrying them at the time of the founding. Despite the opportunity to present supplemental briefing, the United States fails to point to sufficient historical evidence supporting Section 903A's application here. They provide only 2 paragraphs listing potential historical analogs without any analysis of how they are relevantly similar. Now, even though the United States government could not come up with a reason for which they need to have these laws, the court actually indulged them and said, well, let us try to do it for you. I don't think they were necessarily trying to do this to assist the United States government. I think they were actually trying to do this to show just how sparse the government's argument was. Congress might have sought to promote public safety generally. But of course, public safety has always been an issue, and there was absolutely no historical analogs going back to the time of the founding that had any kind of a how or why relevancy to what we're talking about today. Government might be concerned by some combination of postal employee safety and ensuring the efficacy of mail delivery. Well, again, that really interesting thought. That, of course, theoretically has always been a problem that the post office has focused on. I mean, that is their exact purpose. And again, there is no bans dating back anywhere in time would assist in making the post office more efficient. The final concern is that Section 930 might address is intimidation during official government proceedings. But intimidation of government officials during government proceedings has always been a concern, not only of our government, but of every government. And once again, the lack of a historical analog is kind of like silence sometimes speaks louder than words. Ultimately, the corner that the government backed themselves into, and then they were more than willing to argue this, is, hey, listen, these are government buildings. And since they're government buildings, we, the government, gets to say who's in there and under what conditions they're in there. The court, however, wasn't so persuaded. Beyond its scant analogical reasonings and its appeals to dicta, the United States supplemental brief argues that its power to exclude individuals from its own property includes the lesser power to restrict the actions or conduct of visitors as a condition of admittance. This idea does not fit cleanly into Bruin's established framework. Instead, the United States seems to contend that it need not apply the Second Amendment at all to its property. It is one thing for the United States to fail to carry its burden under Bruin to fully marshal the historical record. As I have demonstrated above, the courts can, but need not address such failures by conducting independent historical research. It is another thing entirely to imply that a separate legal principle, whatever that might be, narrows the constitutional right to bear arms outside the Supreme Court's ordinary analytical framework. Okay, as mentioned earlier, Ayala prevailed at the trial court level. The court found that the law, as applied to Ayala, was unconstitutional. The United States government has now filed an appeal that will head to the United States Court of Appeals for the 11th Circuit. This case is a long way from being over, but I gotta tell you that if each of the courts that analyze and review this case sticks to the correct constitutional and analytical framework as announced by Bruin, there is no way that this law is going to survive. The case, one more time, United States v. Ayala. We'll link it up down below so that you can geek out on it for yourself. If you got ideas for videos we should be doing here at Washington Gun Law, go ahead and click on that link right there. Some of the best ideas we ever had weren't really our ideas to begin with. If you got questions about this or anything else related to what's left of our Second Amendment rights, all of the contact information for Washington Gun Law is down in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.